we're at Rasmussen College, Romeoville, and to my left here is the big board. I know you can't see it where you're watching, but that's okay. Let's get started with some foreclosure alternatives. First and foremost, foreclosure. What is it? As illustrated here, it's a process for executing on real estate collateral under the Illinois Mortgage Foreclosure Act. Traditionally, foreclosures take about 9 months from beginning to end. These days, of course in this economy, about 24 months is not surprising. They can still go faster, but there are plenty of foreclosures that take that long. Now what we said to describe a foreclosure was that it's a process for executing on real property collateral, which is a lot of legal mumbo jumbo, which really means somebody has lent money, a bank, and the collateral is your home. And ultimately, when the bank isn't getting paid, its only alternative is to take the home. So, are there exceptions to this 9-month, 24-month time frame? Yeah, commercial property. Generally, foreclosure on commercial property is much faster. In addition, investment property, which means non-owner occupied residential property. So, if you own a little restaurant, if that goes into foreclosure, that'll be a fast process. Or if you own a house that you rent to others, same deal. Now, one thing we should note at this point, there are basically 2 kinds of states when it comes to foreclosure. I'm talking about states in the United States. You have states where a judge gets involved in a foreclosure, a judicial foreclosure state, and states where the judge doesn't get involved, non-judicial foreclosure. Michigan, for example, is a non-judicial foreclosure state. Things go much faster there. But for homeowners, it's a benefit to live in a state like Illinois, which is a judicial foreclosure state. And as an attorney, I can tell you from nearly 20 years of experience, it's very beneficial for the homeowner. Now, let's take a look at the steps in a typical foreclosure, what we've labeled here the road to foreclosure. Step 1, of course, the default. Somebody falls behind on payments. Honestly, we could spend a lot of time talking about a default. Suffice it to say, default begins the minute you're either behind on a payment or you pay less than 100% of the payment. There are many people who can pay all but, say, the last 10% of that payment. And in years gone by, it hasn't been unusual that the mortgage company would let you do that, let you even catch up the next month. That's not happening anymore, especially in a judicial foreclosure state like Illinois. You have to pay 100% of what you owe, and you have to pay it on time, maybe with a grace period. But you go beyond that, you're technically in default. After the default, and let me emphasize this, what looks like a very short period here can be very long. The mortgage companies, they all have their own policies. They have their own way of dealing with defaults. For some of them, it's a big deal. I've had clients who tell me that they've essentially been in default, directly or indirectly, for several years. How? By falling behind. 1 payment, maybe even 1.5, 2 payments, but the bank keeps taking their money. That's a decision on the part of the bank. So this period between default and a foreclosure complaint, which is the next thing we illustrate here, could be fairly lengthy. But eventually, when the bank decides that it has no other way of getting paid, it will bring that foreclosure complaint in summons. So that's step 2. Step 3 is that the bank looks for some kind of judgment. What we have illustrated here are 2 basic kinds of judgments, the default and the summary judgment. Default judgment basically means you've received notice of foreclosure, you've received a summons to appear in court, you haven't done it. Not unusual. After all, if you're behind on your payments, it's hard to explain that away. Either you've made your payment or you haven't. A lot of people simply do nothing, they default. For those who do choose to hire an attorney or go themselves to fight a foreclosure, maybe because they want to make an explanation, maybe because they believe that their situation is different, the sad fact is, again, based on the mortgage document and the promissory note that they signed, chances are the case is all but over. That's called a summary judgment. So you go from a default to a complaint and summons to a judgment of some kind, whether it's a default judgment or summary judgment. The next logical step is the order for sale. Now, order for sale is what it sounds like. It's the foreclosure judgment. Now, many people think, mistakenly, that a foreclosure judgment is sort of the be-all and end-all. The foreclosure judgment comes down, it's over. No, far from it. Let me point something out. Here, running the length of this process from default all the way through to the sale is what's called, in Illinois, the right to redeem. Again, Illinois is a judicial foreclosure state. They get the courts involved. They also have protections built into the Illinois law. It doesn't go in every state. One of the protections built into the law is this right to redeem, which means if you're a homeowner and you're behind on your mortgage, you can get back on the horse, that's the best way to describe it, by paying exactly what you're behind, plus expenses, plus attorney's fees. It's a small amount compared to your mortgage, say $20,000 on a $250,000 mortgage. Problem is, who has $20,000? We'll get to that later. So, the right to redeem runs all the way up to the order for sale. If nothing happens to change that, the sale takes place, and this is known as a foreclosure sale, or more commonly, a sheriff sale. Why? Because usually the sheriff conducts it. And again, in some states, it literally takes place on the steps of a courthouse. It's like an auction. People show up, the bank is there, the sheriff is there, the bank says, listen, we're owed this much money for this house. If you think you can pay us that much or more, we'll give you the house. And once upon a time, certain people would go and then actually buy. Not so much these days. People don't have the money, or for various other reasons, they think they can get a better deal. So what happens is a lot of real estate that goes all the way through this foreclosure process ends up getting taken back by the banks. And once it's owned by a bank, real estate becomes known as real estate owned by the bank. It's very creative. REO property, real estate owned. REO property is a whole separate subject, and it's thanks to people like Lonnie Miller here, who's in the business of short sales and selling property, that REO property moves through the marketplace. Okay, so you've gone to sheriff's sale. Now, as I said, a simple foreclosure judgment is not the end of the line, but neither is the sheriff's sale. Okay, just because your property gets sold on the courthouse steps or whatever, doesn't mean it's over. You know, what happened in that sheriff's sale still has to be confirmed by court. A report has to be made of that sale. The report of sale has to be presented to the court, and the judge has to say, okay, that was fair. And if you're really aggressive, or I should say if your counsel's aggressive, he or she may be able to block that from happening. Now keep in mind, a lot of things have happened. From here to here, as I said, it used to be around nine months. These days it's not unusual if it's 2 years. And still, nobody's out of their home. Okay? In fact, title to the property hasn't even transferred. You are still the owner. As ridiculous as it sounds, you could be 2 years in default, and your homeowners association or your condo owners association could still knock on your door and say, sir, you owe this month's assessment. And you're thinking, yeah, it's funny, I haven't paid my mortgage in 2 years. But it's still your house. Good or bad. That means if there are violations, if the grass is too tall, if the windows are cracked, if it's a public nuisance, it's still your issue. Okay. You've gone all the way to the confirmation of sale. If nobody objects, the sale will be confirmed. In fact, the judge has to. About 30 days after the confirmation, that's when a bank usually takes possession, and right around that same time, they record their foreclosure deed. And that's when the property really ceases to be yours and it becomes REO. It becomes real estate owned. As you can see, there's a lot of play in here. Okay? So for those people, and I've had many clients who are in this position, for those people who think that the notice of default is sort of the end of the line, it's anything but.